Hi, everybody. I just wanted to do an update on what's been happening this week with Elon Musk and the Securities and Exchange Commission. At least one person has said that they were wondering what I was talking about with football. I don't know anything about football. It's not that SEC, it's the SEC in Washington that we're referring to here. Um, it's been an interesting week. Probably the most talked about legal event that involves Elon Musk is that there was a lawsuit filed by Cards Against Humanity in Texas regarding their plot of land that they apparently own, which is near SpaceX's Texas headquarters. It is a brilliant PR stunt, but I think it's actually not nearly as important as this filing that showed up in California sort of unexpectedly. There was a hearing that was scheduled on the docket, and it wasn't entirely clear why. No one had said anything in the case, but then the judge just said, "Hey, we're going to have a hearing." And then shortly after that hearing, uh, a new filing, and this is document 55 in this case, which is titled SEC versus Musk, appeared, and it's entitled Discovery Letter Brief. Now, this is what's called a miscellaneous case. The case number is 3:23 MC 80253 JSC. So the MC in the middle there means miscellaneous case. And that means it's not a full fledged lawsuit, but it's sort of like an ancillary set of filings about a lawsuit that's already going on somewhere else, typically. So you'll sometimes see like subpoenas and like requests for issuing letters rogatory, which is when you're dealing with a foreign country. Sort of weird, random things get put into these miscellaneous case numbers. And so the SEC filed this case in 2023 because they were supposed to be able to get deposition testimony from Elon, which is something they've done in the past. They wanted to do it again, specifically about his acquisition of Twitter. And they had a bunch of questions for him. He showed up to do part of the deposition, but then they wanted him to come back to finish what they'd all started, and he couldn't find a good time. You know, this is not usually that controversial of an issue. When the government tells you that they want you to show up for a deposition, you generally show up. But for whatever reason, Elon said that he couldn't, and this became a big to do. And then finally, the SEC had had enough, and they filed this miscellaneous case in California. So, what are they actually doing here? Why do they care so much? It's interesting because, like, miscellaneous cases don't really have discovery typically. So, when they say discovery letter brief here, what they're referring to is discovery for the SEC. The SEC is doing an investigation. They are presumably trying to build a case. And so the discovery that they're seeking is this deposition where Elon would be under oath and answering their questions. So, um, the facts that they're interested in concern what happened in March and April 2022. So, again, the SEC filed its case in 2023, but by that point, a lot of time had already elapsed after the events in question. On April 4th, 2022, Elon filed what's called an SEC Form 13G. And this form is supposed to tell the world and the commission who is the beneficial owner of a company once they reach 5% of that company that's publicly traded. Um, what made this a little bit odd is that Elon already owned 9.1 to 9.2% of the company, Twitter, by the time he filed this form. The form is required, and you're required to file it within 10 days after you accumulate 5% of the company that you're invested in. So the form was not filed on time. It was not filed within the 10 days. It was filed about 2 weeks after that 10-day period had elapsed. And what's more, the form was not truthful, and the lawyers who helped Elon Musk fill out the form played some games that the SEC many months later decided that it was not okay with and had some questions about. So you can actually see this form on Plainsight or on Edgar, the SEC's database. It's again Form 13G, and it's filed April 4th, 2022. And it starts off at the top. I mean, all these forms are always really confusing. there's a bunch of fields that have numbers like, number one is what is your name, name of reporting persons. But even before you get to number one, there's a thing at the top that says check the appropriate box to designate the rule pursuant to which this schedule is filed. Then you have three options. One of them is Rule 13D-1B. The next one is Rule 13D-1C. And then the third is Rule 13D-1D. It doesn't really give you any explanation of what that means, but what it's referring to is a part of the Code of Federal Regulations, the CFR. And specifically, that's 17 CFR section 240.13D-1. And then that whole section has a bunch of subsections, A, B, C, D, etc. And depending on basically your intent, you might check on this form that you're referring to subsection B, C, or D. And so when I say intent, the intent question is, do you intend to exert some sort of management role or some sort of influential role with this company? If you're just a passive investor who's investing to make some money and you don't really care if the company listens to you at all and you just want to make your money, then no problem. If you're an active investor, that changes things and you have to check a different box. So the box that is checked here on Elon's submission in April 2022 is Rule 13D-1C. And even though it doesn't spell out what that means, it means I'm a passive investor. I don't have any intent of doing anything with this company that would, concern anybody. So then he fills out his name and he says he owns 73,486,938 shares. And yeah, box 11 says, yeah, that's actually 9.2% of the common stock, which is way, way over the 5% threshold. And the rest of it is, fairly unremarkable seeming, and he signs at the bottom. But what any experienced securities lawyer, including the securities lawyers that Elon hired, would know is that there's this thing that says item 10, certification. And the certification is the kind of thing where you declare under penalty of perjury that you say everything in here is true and that you're not taking an active role, etc. And instead of the certification appearing in Elon's form, all that it says in item 10 are the words not applicable, which is not true. Actually, the certification is applicable. And the fact that it's not there caught the SEC's attention because they actually have, as confusing as this all is, they do have a pre-filled out example form that if you're a securities lawyer, you might want to rely on. And the sort of example form that the SEC provides in their regulations has the certification there already written for you. So the fact that Elon sort of skipped that step means that someone actually had to decide, I think I won't put that in there. So that's interesting. So that was April 4th, 2022. Then on April 12th, 2022, so we're talking 8 days later, Elon got sued by someone named Mark Bain Rosella in the Southern District of New York for playing games with the Twitter acquisition, essentially. So this is a civil lawsuit. It's just a private citizen filing this lawsuit in federal court in New York. And it's 8 days after that form was filed. And this person, and this had been in the news, it wasn't just that one person understood this. A lot of people looked at that form and thought something seems fishy here. So that lawsuit got started. And then many months later, in May 2023, Elon and the SEC decided that he's a very busy person, but he would be free to answer the SEC's questions in September 2023. So all that time passed, September 2023 came and went, and he didn't finish answering the SEC's questions. So on October 5th, 2023, the SEC filed this miscellaneous case I was talking about before. They'd sent him an administrative subpoena. If you get a subpoena, generally you have to actually answer the subpoena or go to court and quash it, which means to make it go away. So they filed for an application for order compelling compliance with administrative subpoena, cost the SEC $49. And they spelled out their reasons to the court as to why they thought Elon should be forced by the court to go sit down and answer the questions. So that was October 2023. Um, Now, Elon, through his favorite lawyer, Alex Spiro, basically said that the SEC is just trying to harass me. There's no need for me to do this. The judge disagreed. The judge, I should say, was a magistrate judge. I believe it was Laurel Bueller, and Magistrate Judge Bueller ruled that the SEC was correct here, that Elon could not just not show up. And so then his lawyer or lawyers used sort of a legitimate but very technical, particular trick to slow things down. And what they did was they argued that even though a judge had made this ruling, she was only a magistrate judge. Magistrate judges are kind of like the temp workers of the federal courts. They are not approved by the Senate. And so, under Article 3 of the Constitution, it requires that there be congressional confirmation of judges. And so, because there's not enough congressionally confirmed judges to handle all of the cases in the courts, magistrate judges sort of fill in the gaps. And the way that they get around that is they say, well, this is basically a contract. The parties, if all the parties agree that a magistrate judge can hear the case, then they don't need that kind of congressional authorization for a district judge. And so, this is how the sort of caseload gets shared between district judges who have congressional confirmation and magistrate judges who do not. So, magistrate judge ruled that Elon was incorrect. And so his lawyer said, well, actually, we need to hear that from a district judge, someone who really has the authority to make that determination. So then it went to a district judge. I believe that would be Jacqueline Scott Corley, who used to be a magistrate judge. Sometimes they get promoted. And the district judge also agreed with the SEC and said, yeah, really, this is for real. You do have to actually sit down and answer their questions. So again, all this took a lot of time. Each time someone throws up an objection or an opposition, they have to go through all the motions and figuratively and literally and make sure that everyone's had due process. So this was all a massive time wasting exercise, at least in my opinion. And so we finally got to the point where the SEC said, we've reached an agreement with Mr. Musk and his counsel. Sometime after July, we're going to all sit down and finish this deposition. This is July 2024. So that was a few months ago at this point. This is being recorded in September 2024. And so the thing is, they agreed on a date of September 10th, 2024 to have that deposition finally. This is about a year after they started fighting over it. And it didn't work. Elon didn't show up. So they then went back to court saying, Your Honor, we were supposed to have this deposition. Not only did Elon not show up, but the SEC actually flew people to Los Angeles on the government's dime, on the taxpayers' dime, to be there, and he still didn't show up. So that is where we get document 55, which was filed yesterday, September 20th, 2024. And this document spells out to the court that they would like yet another court order instructing and ordering Elon Musk to appear for the final portion of this deposition. And they say that if he does not appear, they would like there to be sanctions issued against him. Now, people on various websites have sort of, to the extent that anyone has even noticed this, they've said, well, what's the big deal? Obviously there's been a long history here of sort of slap on the wrist sanctions for not just Elon Musk, but extremely ultra wealthy people in general, billionaires. And what's another set of sanctions going to do here? It's not as though a $10,000 penalty is really going to scare someone like Elon Musk, who has $200 billion. But I think that's a very short-sighted way to look at this whole mess, because actually there's two parts to this filing. One of the parts says that if he doesn't show up again, yes, we'd like the court to order sanctions. And it's important to keep in mind, the court ordering sanctions could mean anything. The court has the discretion to do what it wants. But it's not the same as the SEC issuing sanctions. The SEC is notoriously spineless, again, my opinion. But the court may not be quite as spineless. In particular, Judge uh, Jacqueline Scott Corley has had Elon Musk before her in the past in another miscellaneous case, which involved a dispute with Elon Musk and Ryan Mack, who is now at the New York Times, where I believe Elon had issued a subpoena to Ryan Mack when he was back at BuzzFeed to testify regarding the Vern Unsworth case. And as any reporter would, Ryan Mack did not want to comply with that subpoena. And so they ended up in court before, I think, then Magistrate Judge Corley. And she ruled that Musk was trying to harass Ryan. And so she might have some recollection of that whole episode. She might also just read the newspaper and see what's been happening lately. But there is that history there. So the fact that the court has the discretion to issue sanctions is interesting. But also, there is a footnote, and you always want to read the footnotes in legal documents in this filing. And footnote 1 says, if I can find it, pursuant to Local Rule 7-8, the SEC also intends to file a sanctions motion against Musk for an order to show cause why he should not be held in civil contempt of the May 31st, 2024 order to recoup its travel costs for the canceled testimony and for all other relief that the court deems proper. So this is interesting. It means they're both asking for conditional sanctions depending on whether or not he shows up for the final part of his testimony, but also that regardless of whether he shows up, they want civil contempt sanctions. And now, again, being held in civil contempt for a billionaire may not seem like that big of a deal, but this is also a billionaire who is not just involved in, I would say, dozens of legal proceedings right now, including, I should disclose, I am also in litigation with Elon Musk and his companies. So, that's just one of many lawsuits he has ongoing. But as recently, I think, as this morning, the news is that he has backtracked on the issue of how to handle X Corp's presence in Brazil, and he has decided all of a sudden to start removing posts that previously he was adamantly refusing to remove. It is my guess, and again, all this is my opinion, that those issues may be linked because he is now formally on notice by the SEC that they are going to be moving for civil contempt. And one really powerful argument in a motion for civil contempt would be, Your Honor, look, it's not just this case. He also has a history of doing this with even foreign governments. Look at the government of Brazil, which he's been fighting tooth and nail. Well, now he has the ability to go and tell the court, actually, that's old news. That's been resolved. Don't worry about that. That's not an argument for why you should hold me in civil contempt. So these things sort of have a domino effect with each other, and it makes it difficult to maneuver, even if it's not a huge amount of money and he can afford the money. It makes it difficult for the lawyers who are representing him to say things with a straight face where there's so many issues piling up. So there's another set of factors that people should keep in mind about not just this footnote 1, but about the entire process that the SEC is going through here in order to get Elon to sit down and answer their questions. Going back to that case I mentioned a few minutes ago, the Rosella case, it's actually super confusing. It started out as Rosella versus Musk, and now the Oklahoma, let me get this right, the Oklahoma Firefighters Pension and Retirement System. So it's a pension fund in Oklahoma. They have, I think, been replaced, or Rosella has been replaced by them as the lead plaintiff in this case. So now it's, depending where you look, it's captioned Rosella versus Musk, but it's also like Oklahoma Firefighters Pension and Retirement System versus Musk. They're all the same case. Again, that's in the Southern District of New York. That's been pending the whole time, totally separate, also in parallel with the SEC battle to get Elon to sit down. And what's fascinating about this case is that even though the Private Securities Litigation Reform Act, or PSLRA, applies because it is a securities lawsuit in federal court, those plaintiffs, whoever they are on any given day, they were able to convince the judge in New York that they have solid claims. And because of that, they were able to get past the PSLRA discovery stay. And what that means is they got documents. So they got documents from Elon, from Twitter, from all the parties that are involved, and those documents show that, as far as I can tell, Elon Musk and Jared Birchall, his wealth manager, and Morgan Stanley were all basically colluding to break the law and acquire as much of Twitter as possible without anyone finding out. And there are amazing quotes in this case, specifically in the amended complaint, which is document 99. And you can find that on plain sight if you just search for RASELLA, Rosella versus Musk. These quotes say that Birchall and Morgan Stanley, and representing Musk, really were actively trying to evade compliance at Morgan Stanley, which is a huge deal. That they were using expletives to say that they wanted to keep this extremely quiet and make sure that no one at Morgan Stanley even knew what was going on. It's damning stuff in this amended complaint. And what's amazing is that this has all come out before the SEC is even done with its process for their investigation. So why does this investigation matter so much if it's obvious what has happened? We already know kind of from the Rosella case. The SEC needs Elon to answer questions about his intent because it goes back to that checkbox at the top of Form 13G or Schedule 13G. If he intended to be a passive investor, then he can argue, well, he checked the right box and everything was sort of almost not really fine. But if he was always intending to be an active investor by having a board seat, by buying the entire company outright, which is what he ultimately had to do, that presents a serious problem for him. And in this particular case, before this particular commission or agency, he is sort of a recidivist. He has had problems with the SEC before in 2018 when he signed a consent decree, and the consent decree ordered him not to violate securities laws in the United States anymore. So here we are. We have a situation, it indirectly involves Tesla because in order to buy Twitter, he had to sell his Tesla shares. We have a situation where he is credibly accused of violating securities laws, at least in this civil case in New York. They're still investigating it, at the SEC. But if he violated securities laws again, while there was a consent decree in place saying that he can't do that, which obviously you shouldn't be violating securities law in the first place. But when you're specifically told not to, that leaves the SEC with a conundrum. They've got this guy who's on most days of the week probably one of the richest men in the world, if not the richest. And they know that giving him another, 5, 10, 20, whatever $1 million penalty, even $100 million, is not going to change his behavior. He has made it extremely clear for months now, if not years, that he has no intent of actually abiding by any order or decree or rule or whatever the SEC tells him. So there's really only one thing they can do that would have any material impact at all, which is a director and officer ban. And that would mean that he is no longer eligible to be CEO of Tesla or of any other publicly traded company. I don't think they have the jurisdiction to order him not to be the CEO of any company. He probably can still be CEO of a privately held company like X Corp or SpaceX. But he would at least have to step down as CEO of Tesla. And if they were to impose such a D&O ban, director and officer ban, then he would also have to leave the board of directors. Now, obviously, he has a sort of outsized personality, and he might still be able to exert influence even without those official titles. But symbolically, that would be a big deal. It would certainly be likely to affect the stock price. And so a D&O ban is something that I'm guessing Elon Musk and his entire army of lawyers would like him to avoid. It would also be strong ammunition for anyone suing him in civil court. And so, that's something the SEC, I think, is likely considered. I don't have any particular knowledge of that. The SEC doesn't tell me what they're thinking, but you have to imagine that they have thought through the fact that this is a very wealthy individual for whom money means almost nothing at the scale that the SEC can impose penalties. So in order to file a new set of charges against Elon, the SEC would have to complete this investigation. And the thing is, they can't complete it till he sits down for his deposition. And so, what Elon has been doing and what his lawyers have been doing is making it nearly impossible for that investigation to ever conclude. If the investigation ever concludes, then there's no way that the SEC can credibly claim that they've investigated him and reached the conclusion that maybe they have to ban him from being a director or officer. So these things are all linked, and they're not really spelled out anywhere in one document yet, because like a lot of these things have yet to happen, and who knows what will happen in the future. I could be totally wrong about everything, but my guess is they know that it could get bad for Elon. Now, there are a few other considerations here. One is that we have an election coming up in November, which is basically a month and a half away. Um, Nothing is going to happen before the election, because if Donald Trump were to win, then all the effort would be basically pointless. So I think no matter what, everything's going to be happening mid-November at the very earliest, but probably even after that. So that's one factor. The other factor is that the SEC only has civil authority. They can't put people in jail. The Department of Justice has criminal and civil authority. The DOJ can put people in jail. And if you've spent any time looking at SEC announcements or litigation, you know that the SEC and the DOJ like to do things in parallel. And when they file, they like to file the criminal and the civil charges on the same day. So if there were to be some sort of announcement or action against Elon Musk, and we know there's been a DOJ investigation, at least of some portions of his universe ongoing, chances are that would happen at the same time. And so it makes it even more important from Elon Musk's standpoint to delay what the SEC is doing as much as possible, because by delaying the SEC, you might then also be delaying the DOJ. The potential here is that there could be, if there is an indictment on file, it's going to be on file on the same day as the SEC's civil charges. And those charges are not going to happen until this deposition issue is resolved. So I would encourage everybody to read some of these documents, especially the first amended complaint in the Rosella case. Again, you can find that on Plain Sight. I think the link is also in the description for this video. I just wanted to make sure that all of these things that are sort of linked together are spelled out in one place, because I haven't seen any op-eds or articles describing how it all sort of ties together. I would also encourage you, if you haven't read it, to take a look at the filing. I put it in front of the court a few weeks ago, the first amended complaint in my case, Greenspan versus Musk. That doesn't get into the Twitter issues quite as much, but I think it's all of a piece, especially because Morgan Stanley was involved in concealing Elon's Twitter stake as they were building it. And I think Morgan Stanley has clearly been involved not only with Twitter, but with Tesla as well the entire time. So hopefully that clarifies things to some extent. And if you have any questions, you can, I guess, leave them in the comments, and I'll do my best to answer them. Thanks a lot for watching.